Hello everyone, welcome to the class Business Law 210. Our previous discussion last time is about third-party beneficiaries. First about today meeting, we are going to see how is actually um, the agreements for the transfers of rights. Um, there are several agreements for transfers of the rights where the situation might be different if you look at for the following pages, which is actually on your PPT module or PPT slides. The first one is subrogation. The second one is cession. And the third one is novation. What is subrogation? The definition of this term is actually allowing for another party to be substitute in place of a creditor in order to obtain recovery for damages or losses from the debtor. The purpose of this situation is to allow that substitute party, known as the subrogee, to obtain reimbursement for payments they made in connection with the legal claim or debt. The original creditor is called the subrogor and forfeits their rights to recovery to the subrogee, and the subrogee is said to step into the shoes of the subrogor. There are several types of subrogation. The first one is the legal one. You can take effect without a formal agreement between parties. The second one is the conventional, which is specifically started in a written contract. The third one is statutory, where you base on a statute that has been enacted by the legislator. You can see further on the case, on the textbook, where you can see the case between Esso Petroleum Corporation Limited versus Hall Russell and Co. Limited. It was back in 1989. And you can see further for your um, self-reading following this course. You also can check the subrogation link of video, the link of YouTube that I share with you, where you can see some practical example or practical use how subrogation was worked under the actual situation. The next one that I'm going to discuss or share or presenting to you is about cession. Cession is actually voluntary surrender, a giving up or relinquishment of jurisdiction by a board in favor of another agency. In short, this is assignment of property or land to another entity by contract or treaty. The example of this case, you can see Treaty of Paris back in 1803, which compelled France to make a cession Louisiana to United States of America. The example of cession I share with you in the link YouTube, so therefore you can watch it independently and have yourself comfortable to look at this example on your own. The next one is the issue on novation. Novation is a contract that substitutes one party to pre-existing contract for a party who was not in the original contract. When a party enters into a contract to do something for another party, so then the performing party might delegate its duty to to another party. However, the original performing party will still be liable for breach of contract if the party it has delegated its duty to does not perform. This problem can be avoided by something called novation. The case in the textbook, on your textbook, uh, Godrich versus Macquarie Bank Limited, it was happened in 2010, will be good an example for you to look at for this case. Um, there are elements of valid novation that you might look at. The first one is there was a prior valid obligation. The second one is that all of the parties affected by the new contract must agree to the new contract. So then the new contract must show the intention by the parties to discharge the prior obligation, and the new contract itself must be a valid contract. For example, it has all of the elements of a valid contract. The novation and liability, what is actually the relation of both of these issues? A valid novation will completely free the asserting party from liabilities for breaching his original contract, even if the new party that has taken over your duty does not perform. A novation is different than an assignment because with a novation, the party that assigns his duties and obligation to a third party cannot be held liable for any further damages because he is released from the entire contract. And let's see the case related to novation. The case Godrich versus Macquarie Bank Limited. It was back in 2010. Godrich entered into a margin loan facility with Macquarie Bank, which stating Macquarie may assign, transfer, novate, and can otherwise deal in any manner with all or any part of the benefit of this agreement and any of its rights, remedies, powers, duties, and obligations under this agreement to any persons without the consent of the borrower. As part of the sale of its margin lending business, Macquarie then attempted to novate the facility agreement via Banks of New York. Then they, to another margin lender, leverage equities. The leverage equities then made a margin call on Good, Goodrich, and the Goodrich did not comply with that call, prompting leverage equities to sell the underlying security. Goodrich then challenged leverage equities capacity to make the margins call on several bases, and including that the novation of the agreements was not valid. What is the issue was whether a party to a contract can prospectively authorize a novation be made by another party unilaterally and without any further involvement or knowledge of the first party. The court confirms that novation involved the creation of a new contract that extinguishes and replaces an earlier one and in respect of prior authorization of future novation. Hell, it is one thing for the bank to seek to deal with its rights that are assignable rights without its borrower's involvement. It is another for the bank to create and impose a new contract between its borrower enter party in circumstances where the borrower has no participation in or knowledge of the formation of that agreement. The concept of such an agreement is somewhat oxymoronic. oxymoronic. Rare J, the sole judge of the case, held that Clause 21 could be taken to serve as an authorization by Goodrich for Macquarie Bank to bind him to a new contract without him needing to execute a new document. That is all for this topic, and thank you very much for your attention and looking forward to see you in the next section. Have a good day.